The next case to come before the court is Derrick Martin King versus Budget Car Mart LLC. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded as well as live streamed, so please keep your voices up. You should not use the names of children or minors or victims should that be relevant to your argument, and you can refer to them by initials or terms like the child. The judges have read your briefs and are ready to proceed when you are, and I would just ask at this time, does the appellant wish to reserve time for rebuttal, and if so, how much?
Yes, 3 minutes for a rebuttal, please.
Okay, very good. You may proceed when you are ready.
Okay, good morning. My name is Derrick Martin King, and I am proceeding pro se in this case. I have filed a complaint against Budget Car Mart for the purchase of a used car that needed to have its brakes replaced a mere 1 month after purchase, instead of taking the responsibility for the sale of the vehicle that they knew would be requiring major repairs. Budget Car Mart violated the terms of the Ohio Consumer Sales Practices Act and committed an act of fraud. With regard to the first assignment of the error, the facts from the trial court record reveal the following. On December 16th, 2021, I electronically filed with the clerk of courts a subpoena ducis tecum for the production of documentary records directed towards non-party Better Business Bureau of Akron. Document 37 of the trial court record is the subpoena ducis tecum. Document 38 is the instructions for service. And document 39 is the notice issued by the clerk of courts, and document 45 is the return of service, which indicates that the subpoena was served upon the Better Business Bureau of Akron on December 22nd, 2021. In addition, on December 17th, 2021, I electronically filed with the clerk of courts a subpoena ducis tecum for the production of documentary records directed towards non-party Ohio Auto Dealers Association. Document 40 of the trial court record is the subpoena ducis tecum. Document 41 is the instructions for the service upon directed to the clerk of courts. And document 48 is the return of service, which indicates that the subpoena ducis tecum was served upon the Ohio Auto Dealers Association on December 29, 2021. On the issue of subpoenas, the Ohio Rules of Civil Procedure are very clear. Civil Rule 45C3 says, on timely motion, the court may, from which the subpoena is issued, shall quash or modify the subpoena or order appearance of production only upon specified circumstances. If the subpoena does not do any of the following: A, fails to allow reasonable time to respond; B, requires disclosure of privilege or otherwise protected information and no exception or waiver applies; C, requires disclosure of fact known or opinion held by an expert not retained or specifically employed by any party in anticipation of litigation or preparation of trial as described by Civil Rule 26B5. If the facts of opinion does not describe specific events or occurrences, the disputes that resulting from that expert and was not made at the request of any party, or D, subjects a person to undue burden. I will remind this court of the decisions of the 6th District in Metsaluda Enterprise Hills Farms, Metsaluda versus Enterprise Hill Farm, and the 2nd District Court of Appeals in Trick v. Shrieker, in which the appellate court was denied a motion to quash where the movement made was beyond the 14 days after service of the subpoena. In addition, The Summit County Court of Common Pleas supports this proposition of the law. In Summa, Akron City and St. Thomas Hospital versus Western Reserve Hospital, the court held that a motion to quash is due within 14 days following service of the subpoena. In addition, the court in Signet Ventures versus Bates all held that, they also said the motion to filed 48 days after service of the subpoena was untimely. Now, with regard to the second assignment of error, the facts of the trial court record reveals the following. In January 2022, counsel for Budget Car Mart, which is not Mr. Missoula because he recently joined the case, so I will make that clarification. The head lead counsel, Lawrence Raymond Bach, is who I was referring to. He sought to depose me. The document 49 of the trial court record is the notice of deposition. The deposition took place via Zoom, more or less like what we're doing now. And then subsequently a transcript was filed with the court, and I moved to strike the transcript because I was not given notice that the deposition would be taking place via Zoom until it was right then and there.
Mr. King?
Yes.
When you participated in the deposition, were you represented by counsel at that point?
No, I was pro se. I've been pro se this entire case.
Okay, all right. I wanted to just double check that.
Not
and
a problem.
did you? Okay, thank you. Did you object to the proceedings to have a deposition conducted via Zoom?
I did not at that time. I went along with it but I was not aware of the rule that said that you had to have it done in person until it was after the fact. So.
Thank
Do you think because it occurred on Zoom, the court reporter didn't hear your answers and typed stuff down incorrectly?
There could have been any number of reasons why. Mainly the rule is the rule. It said it had to be done in person, unless it's the exceptions are made for stuff like out of state witnesses or anything where or maybe approval. I mean, COVID was a situation at the time, but not at the time of this deposition because it was January 2022, and all the court the court's ruling, the Supreme Court's ruling in regards to remote depositions was no longer applicable because of Governor DeWine striking his previous emergency order. Okay, so we will go there. Now I will briefly address Attorney Mazzola's argument presented in the supplemental authority filing. Specifically, Budget Car Mart is arguing that the court should ignore my arguments regarding the constitutionality on the COVID-19 changes to the various court rules because I had not previously raised the issue before the trial court. I have two responses to that. First of all, an opposition was filed to the deposition, when I filed my, motion to, strike it from the record. And while it is true I did not raise the constitutionality argument on the motion to strike, this was not an issue until the trial court relied upon the COVID-19 administrative actions made by the Ohio Supreme Court. Since this was done in the order issuing the final judgment, the issue is properly before this court, and this court must issue the decision on the merits raised. Okay, with the regard to the third assignment of error, the facts from the trial court record reveals the following. Lead counsel Lawrence Raymond Bach has made several derogatory comments towards me during the course of this case. This lead attorney made comments calling me a quote unquote internet detective and disparaging my math skills and or my legal skills. Document 106 of the trial court record is the budget Carmart's response to my motion for summary judgment, and the comments were made at page 6 of that record. As a direct result of Attorney Bach's comments, I filed a second complaint with the Ohio Disciplinary Council, and they issued an admonition against Attorney Bach. With the Ohio Disciplinary Council admonition is part of this record as an attachment to my motion to take judicial notice, which was not opposed, by the way.
Counsel, I'm sorry, Mr. King, but you're doing a nice job.
Thank you.
Mr. King, I guess I want to make sure I understand the record correctly. It was my understanding that no formal sanction or discipline was issued against him, that he was just cautioned that he's to act in a professional manner in dealing with the opposing side.
There was two admonitions. The first one is what you're referring to. He was cautioned, and then he violated that again. And in August of 2022, the second admonition came out, and that was filed with this court as a motion to take judicial notice. Okay, and then, as a matter of fact, I have it right here. On August 10th, 2022, Senior Assistant Disciplinary Counsel Amy C. Stone made the following conclusions. On February 23rd, 2022, our office dismissed Mr. King's previous grievance against you. In dismissing Mr. King's previous grievance, our office advised you that you have a duty to treat all litigants with civility and professionalism, and cautioned you against unnecessary personal commentary. Mr. King alleged in his current grievance, which is the one I filed after, that despite our caution to you, you continue to make personal attacks against him in filings you made with the court in the civil case Mr. King filed against your client. Our office does not condone such behavior. Your personal attacks against Mr. King in your motion for summary judgment filed on March 14, 2022 fall far below the expected standards of Ohio attorneys and cast the entire legal profession in a negative light. Furthermore, your actions likely violated the Ohio rules of professional conduct.
Mr. King, I just want to let you know that you are moving into your rebuttal time.
Okay, thank you. Thank you for that. I'm gonna let me see if I'm gonna briefly. You know what? I'm going to save my remaining time for rebuttal. Thank you.
Very well. Thank you.
Can I proceed?
You may proceed, Attorney
Thank
Mazzola.
Thank you, Your Honor. My name is Todd Mazzola. I'm here on behalf of CTT Enterprises, LLC, which does business under a registered trade name of Budget Carmart's. The appeal today is from a trial court's order granting Budget Carmart's summary judgment on all counts of the plaintiff's complaint. The appellant raises 5 assignments of error. I'm going to go through them in order. In his first assignment of error, Mr. King asserts his trial court erred in granting the defendant's motion to strike complaints to the Better Business Bureau and the AG and the OADA that were attached and incorporated into his motion for summary judgment in response as not complying with Civil Rule 56 as hearsay documents. Mr. King and the defendant agree that this assignment of error is considered under an abuse of discretion standard. Mr. King's argument that the defendant was stopped from filing a motion to strike because it did not file a motion to quash or a protective order regarding the subpoenas, third-party subpoenas issued to the AG and the Better Business Bureau misunderstands the difference between the process for objecting to discovery and the necessity to support and defend MSJ evidence with 56 Civil Rule 56 C and E compliant evidence. I cited in the supplemental authority a case called New Technology Products out of the 3rd District that discusses the need that evidence given pursuant to Rule 56 needs to be admissible, of a type that would be admissible at trial, and in this case needs to be non-hearsay. Because the documents were hearsay and met no exception to hearsay, they were properly stricken by the court. The appellant never attempted to argue that the documents were not hearsay or that they met any exception to the hearsay at the trial court level. His argument on appeal, and this is really with respect to the 5th assignment of error, I don't think he got to it, that they meet the business records exception, ignores that the complaints were not records made by the BBB or the AG or the OADA itself. They were complaints received by them. Those complaints are unsworn allegations made by persons outside the Better Business Bureau or the Attorney General or the OADA. They're not records made in the ordinary course of business by those that have competent knowledge of the facts, recorded with the self-interest to be served by the accuracy of those entries, which are the requirements of the exception for business records. Even if they are business records in the normal nomenclature, that doesn't take care of the fact of the hearsay within hearsay, that the complaints themselves were statements by people outside that were unsworn in any respect. And finally, I was not able to see in reviewing the record that there was any type of custodian's affidavit or any other type of affidavit testimony that would properly lay a foundation to submit a business records exception under Civil Rule 56 and Evidence Rule 802 evidence. In its second assignment of error, Mr. King argues that the trial court erred in denying his motion to strike his deposition from Budget Car-Mart summary judgment filing because the court reporter wasn't in the room where it happened. Again, Mr. King and the defendant agreed this assignment of error is considered under an abuse of discretion standard. First, the Supreme Court's administrative order, and it's called In Re Use of Technology and Remote Administration of Oaths and Affirmation, expressly permits this. Under Rule D, it says, any oath or an affirmation required by a rule or court may be administered remotely by use of audio or video communication technology, provided the technology shall allow the person administering the oath or affirmation to positively identify the person taking the oath or making the affirmation. That was originally passed as administrative order by the Supreme Court on June 6th. It was extended on 2020. It was extended by order issued on July 31st, 2020. And I quote from that, until further order of this court, I have reviewed the administrative orders that have come out since that time, and there is no order that repeals the specific rule. When it says further order of this court, statements on the masking requirements made by the governor does not count to repeal that. Statements made by this court, the 9th District, about resumption of business as usual doesn't do that. There has to be an order repealing that by the court. So it was expressly permitted, and I don't think that there's any error in not striking it based on that. Second, Mr. King acknowledged on the record of the deposition transcript that the deposition was being taken by notice and agreement, noted no objection on the record to the deposition being taken with the court reporter being remote in this case. Failure to raise an objection to the manner in which a deposition was conducted is a waiver of that objection. And I cite Civil Rule 32C2 for that proposition. The reason is because the objections are made so that any error can be corrected at that time. For instance, if that error would have been raised instead of going forward with a 2-hour deposition, Mr. Bach could have called the court and gotten an order by the court that it go on by remote, which is expressly permitted under Civil Rule 30b-6, as cited by the appellant himself in his brief. Finally, Mr. King also attempts to raise a constitutional issue on appeal that he states that he didn't raise to the trial court. Both State v. Bias and State v. Nelson, cited in the supplemental authority, demonstrate that an appellate court need not entertain a constitutional issue first raised on appeal. And even if you do look to the merits and we get that far, the case that's cited is State versus Stefanko. That case involved a criminal prosecution and proposed testimony by his accuser that the court determined under the Confrontation Clause of the United States Constitution, which only applies in criminal defenses and not in civil cases, offended the Constitution in that case. It's not applicable to this case at all, where it's a civil case, and it's actually the plaintiff himself that was being deposed, not at trial, but at deposition. So I'm going to move on to assignment of error number 3. In that assignment of error, Mr. King argues the trial court erred in failing to disqualify Attorney Bach based on some uncomplimentary comments presented in briefing. He notes that there were grievances and that there were cautions given to Mr. Bach on the case. It's well accepted that disqualification of attorney is a drastic measure, which should not be imposed unless absolutely necessary. I'll have courts further hold that it's not for the court to upset a party's choice of counsel when the facts do not clearly indicate that disqualification is necessary. In this case, the trial court cautioned both the plaintiff and the defendant's counsel that lobbying insults against each other, which happened in the briefing. The court determined that it could go on and didn't need to disqualify any of the parties, and that it could control the docket in the way it did by making these cautionary statements to the parties that were litigating it. And there's no abuse of discretion in doing that. There's no showing that that was prejudicial to any party. Assignment of error number 4, Mr. King argues that the trial court erred in failing to issue a protective order that he requested. The background of that is that Mr. King, as we discussed before, had filed a motion to strike his deposition testimony based on the remote court reporter in that case. Attorney Bach filed a conditional motion. If that were to be granted, he wanted a chance to redepose Mr. King. Mr. King noted in his limited opposition to that and his motion for a protective order that was all in one pleading that he had objected to certain interrogatory questions that were again asked at the deposition, and he was concerned that Mr. Bach would ask them again. What happened ultimately is that the court, in granting summary judgment, did not strike the deposition, did not grant the order for the second deposition of Mr. King, and therefore the motion for protective order was moot. All of the questions that he objected to, there was never a motion to compel him to answer any of those questions. None of them were used in any kind of summary judgment pleading, and there's simply no prejudice to Mr. King based on the court's determination that that was moot, and it was at the time. Finally, he objects in the 5th assignment of error, Mr. King argues that the trial court erred in granting summary judgment. That is obviously, as the court knows, a de novo review. What he basically relies on in that case is the same as it relies on his first assignment of error, that the court shouldn't have stricken any of the complaints filed with the entity, the BB or the AG or the OADA, and should have considered them. As I discussed before, it was proper for the court to strike those. But even if the court didn't, they don't demonstrate what Budget Car-Mart did in this case that would be necessary to survive a motion for summary judgment. The court, this case involves an automobile that was 11 years old, had 140,000 miles on it, was sold as is with no warranties, and which Mr. King bought for under $5,000. the trial court determined there was no genuine issue of material fact for trial because, and I quote, "It's not unfair or a deceptive act or practice for a used car dealer to be unable to foresee brake issues that may arise from a vehicle 30 days after it has been purchased, or a fan belt or air conditioner problem 120 days later." She also addressed the salesperson's statements of subjective opinion that the car was excellent or perfect as statements of opinion that are not actionable as fraud or under the CSPA. There's plenty of law that supports that proposition. In the end, Mr. King did not present evidence of a material representation that he justifiably relied on to his detriment, as would be necessary to support a fraud claim. He did not demonstrate any violation of the Ohio Consumer Sales Practices Act. He failed to meet the burden necessary to survive summary judgment on his claims and fails to carry his burden on appeal to demonstrate that the trial court committed any error. With that, unless there are any questions for me, I cede my time to the court.
Any questions?
Thank you.
Thank
Hearing
you.
none. Thank you. And Mr. King, you will have your 3 minutes for rebuttal. And you're muted right now,
I
Mr.
see.
King.
I'm sorry I did that.
That's okay. It's okay.
It's been a while since I did this Zoom thing. So
For us
Okay.
too.
okay, I'm gonna briefly in rebuttal, I'm gonna he cites a business record exception to hearsay and saying that the records submitted by BBB or the Ohio Attorney, Auto Dealers Association could not be considered business records. They were provided, and while there was no affidavit, there was all what was filed was the same thing as what was given to me under the subpoena. Now, regards to the oaths, again, I mean, there has not been a case yet where they've determined the Ohio Supreme Court administrative orders, with the exception, and he references that these State v. Stefano, like I said, this court has made that clear that even if it is up under the confrontation clause, it's still you got to do it in person. And as far as the deposition objections, the objections were in regards to my protective order. Again. Was that me or was that you? Oh, okay.
Not sure.
Okay. And I'm going to make one more additional reference. And Lawrence Raymond Bach, prior to all of this, is practically accused me of being committing fraud upon the Social Security Administration and the state and the government officials. He did that in a set of interrogatories. That's the reason why the protective order was requested, and it should have been granted. And with that, I'm going to conclude.
Thank you very much, both of you, for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail that decision to each of you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you both again for your presentation.
Thank you, Your Honor.